Good morning, everyone, and welcome to the Morning Blend. I'm Alison DiFlorio, and I am so happy once again to be joined by my partner in crime here, Lori Armstrong Halber. Morning, Lori.
Good morning, Allison.
I am grateful for all of you who have taken some time this morning to spend with us. As if you've attended these webinars before, you know that the Morning Blend is designed to provide our community, our business community, with employment law updates, ever-changing rules and regulations, and then some of the HR trends that we're seeing in the marketplace to try to give you some tips and tricks and help you plan to be prepared for 2026. A couple of housekeeping tips for today. This session is being recorded, so we will send out a recording of the session afterwards. Your questions do matter to us, so please go ahead and put them in the chat if you have them. Lori and I will do our best to address them on the call today. However, if we can't get to something, as always, our contact information will be at the end, and we welcome you to reach out to either one of us. And lastly, we'll have a special announcement at the end of this video that Lori has that she's going to share with you. But to get us started, we do want to talk a little bit. We want to do some brief introductions for those of you who may not know us. I am the co-founder and managing partner of Exude Human Capital, and our firm is headquartered in Philadelphia. We provide HR outsourcing and advisory to organizations who need that extra level of expertise or that extra set of hands to support them through their growth or through challenging times. I hope to share with you today some of the trends that I'm seeing from where I sit and from what we're hearing from our clients. And this is our first appearance with Lori, who has some exciting news to share. Lori?
Well, it's not our first appearance, but it's my first appearance with my new firm, which I'm going to talk about very briefly. But I just thought it'd be kind of fun. Alice and I met pre-pandemic. We were sort of thrown together on a panel to talk about harassment prevention. And, sometimes if you've been doing something in a space for a long time, as we, each had, sometimes there's sort of a clash because you kind of used to your own thing, and when we didn't really have an opportunity to practice. Remember, it was like we met that morning. It was like, all right,
Yeah.
here you go.
Yeah.
And just really connected. And I have enjoyed working with Allison since then and through various iterations in various firms. So all of you who are sort of looking at me going, wait, this is another firm? I feel a little bit like Goldilocks. Like this one was too big and this one was too small and this one is just right. So let me just tell you briefly, for those of you who don't know me, I have practiced in the workplace law space, both employment and traditional labor for almost 30 years, which freaks me out a little bit. I am now the person in the room. I remember being the youngin in the room and going to people and asking questions, and now they come to me. So that's, we all evolve as time goes on. But I really, really, really enjoy what I do. And I have had the privilege of trying cases to a jury. I've had the privilege of working on some leading cases in the traditional labor space. I, as I say, corrupt young legal minds at Temple Law School in my spare time. And I've been doing that for 18 years or almost 20 years, actually, which is also kind of cool. And I serve as a mediator with the EEOC. And so why did I join Constangy? And for those of you who don't know Constangy, because Constangy was born, let's say, 75 years ago in Georgia. And so we probably don't have the same name recognition in the Northeast as some other labor and employment boutiques do. But we are here, and we are 230 lawyers across 21 states, and we do all aspects of labor and employment law. Harassment, discrimination, wage and hour, OSHA, benefits, immigration and traditional labor, and I'm sure I've missed something, but if you have non-competes. So if you have a workplace law problem, somebody in my firm can help you with it, even if it's not me. And this is kind of cool. None of our other boutiques have this. We have a dedicated cybersecurity and data privacy practice, which is another third of our lawyers practice solely in that space and really have a lot of experience and information to share. So I'm very excited about this new partnership with Constangy, and I'm delighted that they wanted to continue our partnership with Exude. So happy to be back, happy to be here this morning and talk about what's going on in the world.
All right. And Lori, you're fresh back from the, was it the ABA conference?
Yeah, the ABA has a labor and employment section, which I'm a part of, but I'm also a member of the Developing Labor Law and Policy and Procedure under the National Labor Relations Act committees. And I just spent a week with fellow traditional labor lawyers, all sides, union, management, government. So, and the newly appointed board members were there for the NLRB and the newly appointed general counsel. So we'll have some updates. And I have a husky behind me who is, I don't know, trying to contribute for some reason, but we'll just ignore him for now.
Okay. All right, so we are, as usual, going to give you some updates from Lori from the EEOC, NLRB, and Department of Labor. There are also some important state law updates that we're going to share, some trends that we're following. I'm going to talk a little bit about the state of the workforce, just share some updated trends that we're seeing. And then, you can never have enough to share about AI and HR. And I know that this you can expect to always have a placeholder in our future morning blends because this is evolving faster than we can do morning blends. So we'll share some updates and some use cases in conversations with business leaders and HR leaders. I've been asking them, as it relates to AI, what would be helpful for you to know? And what I've heard recently is that people want to know, how are other companies using it effectively in their organizations today? So I'll share just a couple of case studies today, as well as a resource that might give you some additional information. So with that, let's go ahead and start in. Take it away, Lori.
Thank you. I will tell you, there was a lot of discussion about AI at this labor conference. And as many of you may think, a lot of the labor lawyers are older folks. And we were all like, as we were talking about AI. So, but somebody said, we really can't be ostriches and put our head in the sand about this stuff. So I'm anxious to talk about that later. Okay, so we're just going to give you kind of some update of what's going on with the federal agencies. It's still kind of we'll just call it an evolving state as to, what the deal is. But these trends are becoming somewhat familiar. So this will be of no surprise if you've joined us in the past year or so. The current EEOC has a decidedly different view on its enforcement strategies, initiatives, and focus. It revoked on January 22nd, so just about 6 weeks ago, revoked the anti-harassment guidance, which had been approved by the EEOC in 2024. That guidance was specifically focused on harassment with respect to gender identity and sexual orientation, which had been added after the Supreme Court's 2020 decision, Bostock versus Clayton County. As you may remember, that is the decision in which Justice Gorsuch, who is a Trump appointee, wrote that sexual orientation and gender identity are covered within Title VII, under Title VII, as within the word sex in terms of the protected classes. So Title VII prohibits discrimination on the basis of race, color, national origin, religion, and sex or gender, which, according to the Supreme Court, includes gender identity and sexual orientation. The current EEOC chair, Andrea Lucas, had voted against it. She specifically disagreed with guidance that related to misgendering. That guidance in misgendering in talking about gender identity and using the wrong pronouns, for example. A Texas district court also struck that particular guidance down last year, saying that it was overly broad and an overreach by the EEOC. A couple things that I do want to note, and I find, please do not take this as a personal view. I mean, it is, I guess, to some degree, but it's very important because academically, intellectually, I think we need to have integrity about these things. And it's a little bit frustrating that the agency that is supposed to enforce the law is frankly ignoring a Supreme Court decision. And I was asked to speak on a panel by the EEOC last summer, and they asked me in my particular segment to talk about the evolution of harassment law from the first, kind of big case, which was Meritor versus Vincent. And that's the first case that recognized harassment as a cause of action by the Supreme Court. That was in 1980. And then we had the Bostock decision. And in fact, last year or 2 years ago, we had another decision that confirmed that sexual orientation is a protected class under Title VII in a, quote, reverse discrimination case. And yet the reviewer removed all references to Bostock and that subsequent decision in my presentation, although I was allowed to talk about it because I don't work for the EEOC and I had the freedom to talk about, whatever I wanted to. I find that problematic. You may remember that last year, and then I'll get off my soapbox, but you may remember we talked about the Loper-Bright decision, which was a Supreme Court decision, recent Supreme Court decision, in which the Supreme Court found that we should not give agencies, the federal agencies like the EEOC, the deference that they had been previously afforded. That is up to the courts to make decisions regarding the interpretation of statutes and things like that. And so it's a little bit frustrating to have a Supreme Court decision that flat out tells the agency, you don't have the authority to do this. And then the agency is doing something else. So, I know politics is everything, but there's an inconsistency in what the agency is doing and what the law says. So what does that mean for you? That means, frankly, regardless of what the federal government is doing, sexual orientation and gender identity are protected under state law in Pennsylvania and New Jersey and under the Philadelphia Municipal Code. So whatever Chair Lucas thinks sort of doesn't matter if you're an employer in this area, because you could be prosecuted under, or sued under one of the other statutes. The other thing that the EEOC has come out, and this is going to be no surprise, we've seen this everywhere, is that they're going to focus enforcement on DEI initiatives with an eye towards, quote, reverse discrimination. Again, the Supreme Court has held just last year, and again authored by a Trump appointee, reverse discrimination isn't a thing. The statute says that we can't make decisions based on race, gender, national origin, religion, etc. And it doesn't matter whether you're white, black, male, female, trans, or whatever. It's that we can't make decisions based on those things. We should be making decisions based on education, experience, performance, and other business-related issues. So,
okay.
All right.
That's interesting. Independent contractor rule.
Yeah, so this goes back and forth with every administration. The Department of Labor hasn't done a ton, like with, we had some discussion about the salary exemptions threshold and things like that. That's kind of sitting out there. But they do have a proposed rule defining independent contractors, which would apply not only to the Fair Labor Standards Act, but also the FMLA and the Migrant and Seasonal Agricultural Worker Protection Act. Under this proposed rule, they would only look at two core factors: the control over the work, the opportunity for profit and loss. You may recall that under the previous administration, there was a 6-factor test. Sort of funny because the current agency's view is, oh, that's way too complicated. We don't know which one to weigh. But, the IRS has a 12-factor rule. So whatever. In my view, these are the two factors that courts have really looked at primarily anyway, right? If someone has control over the work, the when, the where, and the how they do it, and they have the ability to do the same type of work somewhere else, that has always been, I think, a focus by the courts. The rule does make it maybe a little bit more simple to explain and to understand, but this is only in the comment period. So I want to be clear, it's a proposed rule right now. It has not been formalized. They are accepting comments from the public, from various trade associations, unions, et cetera, through April 28th of this year. And after that, the rule will be finalized. And then it will be published in the Federal Register in like 4-point font. And in the next update, I'll let you know that it is now finalized. The other thing the Department of Labor is talking about is AI.
Shocker.
Yeah. Well, this is really kind of crazy. I don't recall the DOL ever doing this, but maybe I've just missed it. But on February 13th of this year, they released a quote comprehensive AI literacy framework, providing employers with a roadmap for how to train workers to use artificial intelligence technology responsibly and effectively. It doesn't create any legal requirements, but it does create kind of a signal of what the agencies are thinking about. Now, this is consistent with one of the Trump administration's initiatives regarding the use of AI and stepping up, I guess, the American workforce's ability to participate on that platform. So
I did a little research into this, and I think this is really interesting for those of you listening. So if you go to DOL, look for do a search for competency model clearinghouse, and there's an incredibly useful tool that has been developed by the Department of Labor in conjunction with the Employment and Training Department that shows you this framework around the key skills and competencies that people would need to be to develop in this digital world that we're in. Really interestingly, now this is not finalized, but it's available for you to view. They have a create your own tool so that if you want to be able to create your own internal competency model for how you're going to train and develop employees to become AI literate, you can use this tool to it'll populate with their competencies, but then you can modify it to really fit the needs for your particular industry. I think it's a huge time saver. We talk about creating competency models and things for other pieces of the organization. This is industry specific. So I took a look at the drop down of the different industries. Chances are yours will be there, but I would definitely check it out. It's the Competency Model Clearinghouse, and it's under construction, but there still is a lot of information on there and useful tools and resources for you to take a look at. And when I said shocker, it's about this. I'm glad that they're actually elevating AI to help the workforce and employers stay on track with this quickly evolving technology. Okay.
all right. So my week, I feel like my week in camp, you write a letter home. So, and I apologize. I don't remember if we were talking about this before. I guess we were talking about this at the beginning of the session that I just spent a week with these folks. Um, and you can thank me for the lovely weather because it was in Hawaii and I seem to have brought back the nice 70 degrees with me. Couple of things
All right. I didn't mean
that
to go back.
oh, that's okay. That are of import to some degree. Again, remember the National Labor Relations Act does not only apply to unionized workforces. So I'm mentioning these things. Some are more applicable to a unionized workforce, some are applicable to everybody. So one is the joint employer rule. They have issued a final rule on what it means to be a joint employer. It is more, I would say, how do I put this? More employer friendly in the sense that, and we see this swing, depending on who's who's holding the White House, who's holding the administration at the time. But whereas I think under the Obama administration, there was sort of this fear that, like, if I have an office and I'm hiring a landscaper, that somehow I'm a joint employer with a landscaper because we have a contract and I have the right to reject one of the workers if I don't, like something that they said. That would have led to joint employment under the Obama administration, maybe. The current joint employer rule is much more employer friendly, requires actual integrated control and other factors. It only becomes important to folks if you are involved in something that maybe there's like an unfair labor practice charge. So, for example, if you use temporary workers and they're kind of embedded in your workforce, and there is a push to unionize, then whether or not they get counted, whether or not you're a joint employer would be potentially at issue. Or if you, let's say you found out that one of the temporary employees was making noise about organizing, and then you remove the temporary employee, you say you don't want them anymore. If it can be established that they are that you're a joint employer, then you might be liable for an unfair labor practice charge with respect to that action against that employee through that theory, even though you don't directly employ them. So that's how it comes into play. It's probably not an issue for most of the folks who are here with us today, but if you have questions about it, I'm happy to talk about it later. One thing that came down that was sort of interesting is that the new general counsel for the board, whom I know well, she was a board attorney early in her career. She's been a partner at Morgan Lewis most recently, and has been at Morgan Lewis for a number of years. She was just confirmed as a general counsel. And previously, general counsels have sort of set an agenda by issuing a mandatory submission to advice memo. What that means is telling the national relations, NLRB is broken into geographic regions. And so if somebody files, we call it a ULP charge, but you, like the same way you would file a charge with the EEOC or a complaint with an agency, it's called a ULP charge. So if I file a ULP in Philadelphia in Region 4, they used to have to look at this mandatory submission to advice memo and see, is this a, quote, hot topic that the general counsel wants to see? And she's not doing that. She's like, if you think that it is a violation of the law and you need guidance from the general counsel's office, you can bring it to us. But there is a backlog of charges right now because the prior administration had a very long list under the mandatory submissions memo, and the staff has been overwhelmed. ULPs have been sitting for investigation for well over a year, sometimes 2 years, which is not great. And so part of her initiative is to let's get through what we're doing and let's not create new work. People are perfectly capable of reading the law and filing a charge if they believe it's appropriate. With respect to that, they have a new protocol where before you would kind of file a charge, you didn't even have to support it. Now, if you file a charge, you have to give some sort of preliminary information to show that the charge is valid, and you have to do that within 2 weeks. And at that point, the region will make a decision about whether to further investigate or to dismiss the charge. So all of that is kind of a streamlining and, a refocusing on what's going on at the board. The thing for everybody to know, and this is a good thing, is that they're going to be more judicious in their handbook review. So before, this was her quote, we're not using the handbook review as an opportunity for fishing. We should only be requesting relevant handbook provisions and only investigating them to the extent that they relate to the specific charge, as opposed to under prior administrations where you'd be questioned about your confidentiality policy. They'd ask for your whole handbook, and then they would find 3 of the policies that violated the act. They're not doing that anymore. There were cases that determined how the review should take place. Boeing was the case under Trump 1, and that had specific categories of work rules. Some were per se violative, some were kind of in the middle, and some were considered de minimis. under this is still good law under Stericycle because this happened over the past administration. I hope you guys cannot hear that dog woefully crying in my background. This talks about rules being presumptively unlawful if an employee could reasonably interpret it to chill protected activity. In other words, if an employee might be like, ooh, under that rule, I can't talk about terms and conditions of employment, then it would be presumptively unlawful. I will tell you, the general counsel did not say this. The new board members did not say this, but it is very clear that they believe Stericycle was wrongly decided and that it is too restrictive for employers in their handbook. So anyway, good news overall. Your handbook should still be reviewed periodically to make sure that it complies not only with the National Labor Relations Act, but with other statutes as well. But we don't have the kind of intrusive enforcement that was going on over the previous 4 years.
Okay.
And then I think we just have a couple of updates that are federal and state that just sort of I thought you might want to know about. I know non-competes are sometimes an issue for folks. The FTC, if you remember, had a rule. The rule was in, the rule was out. Then we said the rule was dead. Well, the rule is still dead. That was the rule that was going to make them presumptively unenforceable or voided. That rule is dead, but the FTC has signaled that it's still pursuing an aggressive enforcement agenda when it comes to abusive non-competes. And what that means is they're going to enforce it at a higher standard, be more strict in making sure that the restrictions aren't overly broad or overly restrictive. So if you use non-competes, you should really have them reviewed. Make sure you're really using them in appropriate ways and not overly, non-competes for everybody are usually not appropriate. Maybe if you work for Coke and you have everybody sign something with respect to the secret formula, but otherwise it's usually for either sales folks or people who have real access to confidential proprietary information. USERRA is the Military Leave Act. We have the high, as of January, the highest military leave use that we've had in 20 years. And I don't say this blithely, but it seems as though you can expect, or we can expect, that there will be an increase even more so given the current state of things. Just a couple of key highlights. If you're not familiar with this statute, it's a federal law. There is a prohibition against discrimination and retaliation. You can't deny employment or reemployment or any other promotion, benefits, etc., based on somebody's application for service or obligation for service in the armed forces. And if somebody has to take leave, you cannot retaliate against them either. They are entitled to a continuation of benefits for up to 5 years of during their 5 years of unpaid leave. They can have let me say that again. Someone under USERRA can take up to 5 years of unpaid leave during the life of their employment to fulfill their military obligations. And throughout that period, when they are on leave, you must maintain their seniority, healthcare, and pension benefits. Returning service members have, it says here, nearly an unfettered right to reemployment to their pre-service employers upon timely application. USERRA is complicated. It's enforced by the Department of Labor. It's a little bit counterintuitive. They don't necessarily have to provide you with something in writing to justify the leave. There are some FMLA provisions that also apply to military leave. And so if you find yourself with a question and you don't have regular counsel to help you navigate this, I'm happy to do so, or happy to connect you with someone who can help you. But I do think this is something we're going to see, so I wanted to make sure we talked about a little bit this morning. And then finally, 2 state law changes for our friends in New York. Most of you know this. There were amendments to the New York Earned Safe and Sick Time Act, which took effect on February 22nd, which is kind of a weird date, but be that as it may. And it really expands time off. In addition to the safe and sick leave that's paid, you must provide 32 hours of unpaid safe and sick time to covered employees, in addition to that paid safe and sick time that was already provided for. The covered uses have expanded to reach new circumstances, including caregiving, pursuit of substance benefits, I cannot speak today, subsistence benefits, or housing related to workplace violence and public disasters, which would include weather events and certain other things. Again, it's much more detailed than we have time to go into, but I at least wanted to highlight it. If you have specific questions as to how it applies in New York, you are welcome to contact me or contact your regular counsel and make sure that you have updated your policies accordingly. Finally, for those of you in Pennsylvania, you may be aware that there's a Criminal History Record Information Act that prohibits the use of certain criminal records in hiring and employment decisions. Historically, that has really come through obtaining information like through a criminal background check or something. So, for example, you can't use arrest records. Criminal records are limited to relevant crimes. So, for example, somebody was convicted of embezzlement and I'm hiring a new accounting clerk, that's a close tie. Somebody who has a pot or weed possession thing from 20 years ago, probably not relevant to whatever you're doing now. You can't use that in those employment decisions. Well, the Third Circuit just looked at a case where an applicant voluntarily disclosed some criminal history, and it was unclear whether the applicant's voluntary disclosure was covered by the statute. The Third Circuit said it is. So again, if you're dealing with an applicant or an employee and there's either criminal history or a background check comes back and you need some assistance in navigating it, please do, check with counsel or you can give me a call. I'm happy to walk you through it. So those are the kind of latest and greatest in the legal world. So Alison, let's talk about HR stuff.
Let's talk about the HR stuff. And I just want to give a shout out to Holly. Thank you for dropping the link to the competency model into the chat. I appreciate that for if people didn't see that there. We'll also include it when we send this out post session. So what's happening in the workforce? I don't think this is going to be any surprise to any of you, but obviously AI integration and displacement. What's interesting is that this is the first time we're actually seeing large layoffs attributed to the efficiencies of AI. So I think you saw some of the major tech firms did some pretty significant layoffs in January and February. This has created a heightened level of stress on the employment front, as you might imagine. So you see that increase of 20 to 40%. With that, fear of job security comes additional anxiety that may show up in different ways in a workplace. So I can just tell you what we have seen, and it's not just from AI, the fear of AI, but just the heightened level of job security in general is some conflict arising. People are on edge, and just be prepared as employers to address that conflict and to support your managers in addressing that conflict so it doesn't sit there and fester. We are seeing labor shortages and demographic shifts. So we've got people who are saying they cannot fill jobs, even though there are people out there, but they don't have the right skill set for the jobs that they're looking for. It says trades and manufacturing, but we're also seeing that in healthcare. We also know that we've got, the I think it's like some 59% of people are of the workforce are saying that they are planning for retirement over, the next 10 years, which means we're going to have a loss of knowledge. So we have to start planning, and we have to start preparing our existing staff and think about creative ways to address this demographic shift. The never-ending return to the office versus flexibility. So this is in greater demand, particularly with Gen Z and Gen X. People want that flexibility, even if it's only one day a week. And many organizations are really still struggling with how to get some sort of commitment for people to return. We've spoken about this on the last couple of morning blends, but it continues to be an area that you're going to want to focus on. Consistency is key, and flexibility is key. And flexibility can mean a lot of different things to different groups of people. Immigration and compliance, that's continuing. I will say that we still continue to find organizations struggle with keeping their I-9s up to date and organized in a compliant manner. So just if you haven't done it, just take a look at your I-9s, make sure that they are all up to date, make sure that you're following process, and that you correct any ones that may not be completed correctly. And then we're going to talk a little bit about AI, but what we're seeing now is that 79% of job candidate applicants are using AI to apply for jobs, and that's creating like massive volumes of applications for people who it becomes a little bit challenging to determine how qualified they are for the role. So we're going to talk a little bit more about that and how you get your arms around it and manage that volume, but then also really identify the candidates that truly have the skills that meet your needs. In terms of what that means for employers, we've been talking for the last year or so about skills-based hiring. 65% now of employers are reporting that they are adopting that skills-based hiring. We're going to talk in a bit about how to more effectively train your AI if you are using AI. And by the way, if you're using ATS systems, you're using AI because it's embedded in the recruiting piece. And that doesn't come without some risk. We're going to talk about retaining older workers. What we are seeing is employers are becoming more creative in how they are creating flexible or part-time roles to retain older workers a little bit longer to be able to do knowledge transfer, but then also to mitigate this kind of labor shortage, if you will, for some key and critical roles. So I think about that, having those conversations, thinking about where you can be flexible to be able to accommodate older workers, to maybe keep them an extra year or so in a manner that's going to help the organization, help the individual. And then the current environment really is creating a shift from kind of reactive hiring to proactive hiring. And I will tell you, a lot of employers struggle with this. It's this hurry up. Our managers need to fill these roles. How do you get ahead of it? So we'll talk about and how do you develop retention strategies to navigate the labor market through this technological disruption so that you can maybe keep people a little bit longer so that you can fix this kind of this churn. So all of this means for the HR people on the call, there's more work for you to do. And we know that you have limited bandwidth. You may be a shop of one, you may have a small team, and I guarantee that you all have very full plates. So this is where AI can be helpful to you. It can be helpful and it can be a time saver. But again, we're just going to focus on a couple of things today and a couple of use cases about how it's being used effectively. Job descriptions. We've talked about skills-based hiring, like hiring for skills. One of the things we have to be mindful of is that the ATS systems and the embedded AI job search functions generally are going to search for candidates based on job titles. Unless you work with them and if you get the resumes in, you train your AI to be able to look for specific skills. Remember, job titles across organizations may not line up by skills or responsibilities. A program manager in one organization may have a very different set of responsibilities a program manager in another. So you could get 1,000 resumes for program manager, but really only, 50 of them actually have the skills that you're looking for. So I know job descriptions are time consuming but they're an important, critical document for you to have in order to find the talent that you're looking for. And AI can save you the time to do that with the appropriate prompts. Compensation, we talked about this a few times too. It is being used for benchmarking, job leveling, and pay structure. One of the things I do want to point out is that while it can save a lot of time and it can give someone who may not have expertise in compensation kind of a quick way to get information, it also is dependent upon how well you prompt and inform, and all of this requires human oversight because just because it creates a job level for you, it doesn't mean that it's understanding your business or understanding the roles and responsibilities of your job to create job levels appropriately. And that could impact the information that you get for benchmarking, um, uh, and could impact your pay structure. Performance management. People are using AI in performance management. They're using it to draft reviews. I'm going to talk about this on another slide. Can be a huge time saver, can be a huge time saver, but it doesn't come without risk. And you have to make sure there's human oversight. So we'll talk about that as well. The other big piece in training plans is creating training plans. Now, we get requests for this all the time, and it's time consuming. When you have a lot on your plate, training plans isn't always a need to do, it's a nice to do. However, when we're talking about trying to retain staff or attract the kind of talent we want, job seekers are now asking openly about what is the plan for me to develop while I work for you? That's something they openly ask about. And your ability to be able to show them the training path or provide them with the appropriate skills, provide them with the appropriate digital learning if they need to, is going to be critical. So we'll talk in a moment about how AI can help you with that. And then lastly is the policy development. We've talked today about, updating policies and those kinds of things. AI can be very helpful in that. But again, it's not always going to pull information that is most current or that covers your federal, state, and local laws. And it does require that oversight to make sure that it aligns to the culture that you're doing. Lori, I don't know if you want to add to any of this, if you've run into any
I,
bumps.
I do. I want to tell you that, I mean, even lawyers, we are using AI for various reasons. To the extent we use client information, we have certain ethical protocols we need to follow, including disclosure. Um, I will say, for a quick hit, so you might be inclined to like Google whether something's legitimate or whether you can include it in your policy, and you'll get an AI response and it'll seem to have sources. And I will tell you that a good number of times the information that you get is incorrect. How do I know this? Because I myself might start with a Google AI, let me just quick hit so I can get to the statute that I'm looking for or whatever. And the summary that you get is sometimes the opposite of what this case says or what the statute says. So I just caution you um, against AI. Is not, I think it will get there, but it's not there yet. And
Yeah.
even legal tools, even within the legal community, we have our own specialized AI, and even that has hiccups. So everybody is very mindful about double checking and triple checking and going back to the main source to make sure that the information you're getting is accurate.
Yeah. And I do want to note here, you'll see that a source, McLean and Company, came out with a report on AI and HR primer with use case ideas. So I want to share some of the information there because, how you ask for things in AI can also help get more accurate information. But again, you never use it without human oversight, right? It doesn't do that for you. But some of the prompts that we have, that this report that McLean came out with, I think are really helpful, um, are things like for a job description. Think about your culture, think about what the requirements are, but draft a clear, inclusive job description for you name the role in the particular industry. You might want to use gender neutral language and focus on essential skills. Essential skills. Remember, we're trying to look for skills rather than just the job title. You can do the same for resume alignment. You can use it in that space. The other space from a recruitment or talent perspective is to use it for interview questions. And we've talked many times about the value of behavioral based interview questions. If you don't have them, this is a way to at least generate some initial questions for you to share with hiring managers. Obviously, you would want to review them, but think about the types of competencies that you're looking for, or skills for that matter, and ask in your prompt to generate the structured behavioral questions that assess, and you fill in the blank: collaboration, problem solving, accountability. But be as specific as possible when you're filling in those prompts. Training plans we mentioned, this is a new expectation of, not a new expectation, it's always been there, but now job seekers are actively asking about it and seriously considering what that means for their decision about working with you. Obviously, human review is required for generated training plans, but this can be a huge time saver to at least get an outline of what a training plan could look like. Depending on your industry, you may have required training, mandated training, you may have compliance-based training, and then you have developmental training. So think about using prompts like you see here: curate let's say a 6-month learning plan for I'll use program manager again, to learn whatever the skills are, and include a variety of sources. So you can name those sources: podcasts, books, videos, articles, practice activities. Remember, this doesn't, training and learning doesn't always have to be formal, bringing outside facilitators in. There are a lot of different venues that you can use. Please, 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 though, if you get a list of recommended podcasts and books and videos and articles, review them, read them, and make sure that they hit the mark for what you're looking to do. Or draft a timeline development plan, or draft a development plan, 6-month development plan for program manager aspiring to be a director. Let's say that. Include development of strategic leadership, of managing others, of you name the competency or skill. And remember, you can put it in there, you can revise it, but this is a way for you to be able to add value to an organization by providing a training plan to help retain talent, or again, to help cover talent. Lori, I don't know if you want to add anything to that.
You're going to talk about performance reviews, right?
I thought I had a slide in here, but I want to talk about them now. Let me see if I do have one.
Because I was going to relay this story and I was waiting, but maybe now's a good time. So one of the panelists, a union lawyer, was talking about, she and a management side lawyer were talking about the use of AI in collective bargaining. Not that part's not that interesting, but she represents nurses. And they were talking about, she was relaying this situation where the hospital was using AI in the performance review process, and part of what they were doing was to read the notes that the nurse was putting in for the patients, and flagging certain words and those words then were used to assess some kind of score, right, as to like how patient friendly the nurse was. But, and this again is the key to human oversight, it was scoring the word jerk as a negative for nurses, and reducing their overall patient care score, whatever the score was called, where the nurses might be using jerk to describe the physical movements of a
Oh
patient,
my
like if they're having
goodness.
a seizure, right? But AI doesn't differentiate, or at least not yet differentiate, jerk, meaning the patient is a jerk, versus jerk, the patient is exhibiting seizures by jerking, their body is jerking or what have you. So just
That's a great example.
another example, and I thought it was really interesting.
I will talk about performance reviews, and thank you for bringing that up, because one of the things you really have to be mindful of is this does not mean you use it to take the place of you as a manager writing a performance review. Uh, it can help streamline and clean up the language a bit. But you always want it to be an authentic review. Your prompts for performance reviews need to be very thorough and include, include highlights from the past year's performance around customer service accomplishments, uh, reporting detail and timeliness, very specific kinds of things. And then you read through it and you can add in your specific examples to make it come to life. Obviously, with performance reviews, you want it to feel personalized, customized to the person. So you've got to include those examples of what was demonstrated to show to reinforce that behavior so that you can see it again in the upcoming year, or that they can redirect it as they continue to develop. So again, it's a time saver. I know this time of year, many people just got through the performance management cycle. Some of you who are on a fiscal year are probably gearing up to start that cycle in April or May. And it can be a little daunting if you manage a lot of people. So these are, AI can be a supportive tool to help expedite that process, but it does not replace the human oversight. One of the things that we are seeing more organizations do, and it's strongly recommended, is to create that cross-functional team to talk about establishing policies and governance around AI use in your organization. And we say cross-functional because the needs will be different. Obviously, if you need to get legal guidance, you can reach out to Lori about what any proposed policies or governance that you have. We're happy to talk about it. If my colleague Romaine Jones-Wise has done a lot of speaking on this topic in the last few weeks, and she'll be up again in Boston later this month, speaking to a group of CHROs in that area, talking about how to start thinking about establishing policies. But these policies have to be designed to give guidelines on how it will be used and then how it will be enforced. The other piece, and I believe we may have mentioned it on a previous morning blend, your vendors that use AI in their systems, whether it's for recruitment and selection or training or anything, you've got to make sure that they are doing their regular audits for mitigation of bias in their systems. So ask them, if you're considering looking at a vendor, ask that question. What is your process for auditing results and mitigating bias? Because that, I would imagine, Lori, there have been laws that have come out where you have to disclose to employees that you are using AI as a piece of an employment decision, correct? Like I know California, Colorado,
Yeah, I think
Oregon.
New York maybe. I don't, I'm not up because there are so many and it's constantly
Yeah.
evolving, but there is much like you see in use of other information, like during a credit, Fair Credit Reporting Act and criminal background. It's conceptually similar to that. We're using
Hmm.
AI in this way. Some, I think, give the employee an opportunity to, I'm going to call it challenge or question,
Hmm.
to kind of have a review. But yeah, I think we're going to see more of those laws as AI is more and more prevalent.
I agree. And I'd also say I would imagine this could happen pretty quickly because, as you all know, the pace that this is being integrated into our day-to-day and our workplaces is faster than really anything that we've seen before from a technology standpoint. So the sooner you can establish this kind of cross-functional team and really start talking about it, and maybe some of you already have, but it's strongly encouraged.
I think California, just to answer your question, was the first one. It's really focused on discriminatory use of AI, and that
Mhm.
was passed effective October 1st, 2025. But
Yeah, and like I said, I think there's some other. I want to say Oregon and Colorado also have that as well. But just to kind of recap, establish an AI oversight group. just you want to get ahead of this as best as we possibly can. Review the policies. Lori talked about some of them today. Think about your workplace flexibility. Identify areas of concern and take action to address. With workplace flexibility, again, decide on whatever your model is, and then hold people accountable to it across the organization. Uh, Otherwise, it just kind of it just it creates an engagement issue. And lastly, and we always say this, I think we always end with this, is educate and support your managers. In these times, it is critically important that your managers remain empathetic and that they communicate effectively when there's a lot of change, when there's a lot of things happening externally that carries over into the workplace. So just make sure your managers are being equipped with the appropriate tools and resources and skills to be effective.
One thing to note that just because there aren't necessarily specific AI statutes, most states have existing statutes that would cover AI if the tool results in a violation of law. So, for example, disparate impact. If you're using AI and it screens out all of a particular protected class, that would be discrimination on a disparate impact theory based on the use of AI, even though it's a separate rule. Or data privacy laws, for example, might be implicated. So I want to be clear that yes, California has a specific statute, but a lot of states have existing statutes that might cover use of AI.
Yeah, and you just reminded me of something else too that I should call out. Uh, this oversight group should establish which AI apps you will be using as an organization. Copilot is built into Microsoft Office system, but you want to make sure that people aren't just using anything, and also that you're never putting confidential information into AI, right? So it wouldn't be Alison DiFlorio's performance review that's going into AI. It would be a performance review for someone with this position who is, you're looking to evaluate these things. So all of these are questions that you don't have to be the only person responsible for solving, but as HR in an organization can take a role in making sure that you're pulling together the right group of people to help create those guidelines. And lastly, I said that I do want to open it up for your questions, but while you're thinking about questions, we wanted to have a little public service announcement for
Nala,
any
come here.
dog lovers who are out there.
Nala, come
Um,
here.
we have
Nala.
we have a dog that is up for adoption that Lori is fostering. Do you want to introduce?
I can if I can get her to cooperate. Can we sit up? Can you sit up? Come on. Now's your chance to show off. Say hi. Can we see you?
Okay.
There's Nala. Nala is 40 pounds of complete love. As you can see, all she wants to do is sit behind you on the chair or at your feet. She was rescued from ACCT in Philadelphia she was on the list. She does not like crates, so she's not super great in a crate, but she's not destructive, and she is just kind of a love. We take a nice walk or a run. She's fine either way each morning. And then all she wants to do is be with you all the time. She gets along great with other dogs, except for my Huskies, but I think that's about me, not them. She has spent a lot of time with both of my daughter's dogs. She spent a week and a half with my older daughter and her dog, and they got along great. She's good at the dog park. She is pretty low maintenance, and she is looking for her forever home. Unfortunately, her owner was deported, and they left her behind in a parking lot. And so she's just looking for somebody to love her and to be her person. So if you are interested, you can reach out to me, or you can reach out to Philadelphia Rescue Angels. She's on their website, but we are looking for the best forever home. So if you know anybody who's looking for a sweet companion who will be loyal and snuggly, but could also hike and run if they're active, then she is your girl. So let's see if I can get it. She's like kind of half asleep. Let's see if I can get her up again. Can you say bye? Can you say bye?
Beauty. She's a
So,
beauty.
So
I don't see any questions in the chat. Again, Lori and I are happy to talk offline if things do come up based on anything we've talked about or any other employment issues that may arise. We want to thank you once again for joining the Morning Blend. We will have we'll have a webinar, a
it's
webinar in
June.
April coming up. What's that?
Oh, you have a webinar in April. I thought you meant our next morning
No,
blend.
yeah, our next morning blend is in June, but we do have a webinar coming up in April that we will share information on when we send out our follow-up. But on behalf of Lori and I, first of all, Lori, thank you again, and congratulations on your new firm.
Thank you. If you're looking to be included in my firm's newsletter, which is great with updates on what's going on in statutory and case law developments, just shoot me an email and I'll add you to the list. And thank you, Alison, as always, for your partnership, and great to see you.
Thank you. Great to see you, and great to hear all of you, and we appreciate you taking time to chime in. Have a great rest of your week.